The following podcast contains graphic content that may not be suitable for all ages. Discretion is advised. The views and opinions expressed in this podcast do not necessarily reflect the views of Premier Wrestling, its subsidiaries, or its sponsors. Access to this podcast does not constitute legal advice and does not create any attorney-client relationship. If you require legal assistance, please contact an attorney. All subjects are innocent until proven guilty in a court of law. Hello, everyone. I'm Efren. Tonight, we present a very serious discussion. You have heard from plenty of talking heads giving commentary and opinion on what they think of the allegations against former chairman and CEO and founder of WWE, Vince McMahon. But tonight, I will be asking questions to a criminal defense attorney and discussing the law like you have not heard before. This is Special Report, the complaint against Vince McMahon on Premier Wrestling. Tonight, we have a veteran trial lawyer and lifelong wrestling fan from Wichita, Kansas. He has been practicing law for 13 years, is vice president of the Kansas Association of Criminal Defense Lawyers, and is a partner in the law firm of Holdnick, Stang, Gehrig, and Leavitt. Please welcome to Special Report, Matt Leavitt. Matt, how are you doing tonight?
I'm doing well. How are you?
Good. Thank you for doing this.
It's my pleasure.
You have read this 67-page document like I have. It's been a little bit over a month, and we are going to go through it in relation to the law questions that we have and stuff that only you can answer. After reading this for the first time, Matt, what are your initial thoughts on it?
It's an extremely well-crafted legal document right off the bat. It lays out in almost painstaking detail all of the accusations. And as we move through this, I think that people will understand why it's crafted the way that it's crafted.
Let's get into it. We start right off the bat with page 1 here. The legal definition of sex trafficking, as mentioned in the complaint, is the recruitment, harboring, transportation, provision, obtaining, patronizing, or soliciting of a person for the purposes of a commercial sex act in which the commercial sex act is induced by force, fraud, or coercion, in which the person induced to perform such an act has not attained 18 years of age. Break that down for us, Matt, so it's easier to understand for people who aren't lawyers or legal people. What can you add to this?
Well, it's a very broad definition that encompasses a lot of different acts, and that's by design. This is all going to fall under the Trafficking Victims Protection Act, which was originally enacted in 2000. And that specific definition is a federal definition of human trafficking as codified under 22 of the United States Code, specifically subsection 7102.
Okay. I know what none of that means.
Well, so what we're talking about is we're talking about the written definition under the law, the actual written law that legislators at the federal level, so the United States House of Representatives and the Senate, have deemed the appropriate definition of human trafficking. And that's codified under that definition section. So anytime that the federal government is looking to try to prosecute someone, or alternatively, if anyone is looking to file a lawsuit because this has happened to them, that's the definition that they have to fall under. Those are the elements of the offense that they're going to have to prove up. And getting really, really down, sort of breaking this down, it really comes down to a power dynamic. It can be something as slapping you in the face as someone actually taking someone by force or fear over state lines for the purpose of a sex act, or someone who does not meet federal age of consent being induced or coerced into a sex act. But it encompasses so much more than that. It's a very broad definition. It gives far-reaching authority. So it's not necessarily what we think about. The term traffic might we might think of that in terms of someone again being smuggled over state lines or being brought over state lines. But again, it's so much more broad than that in the grand scheme of things. And it comes back to circling back that power dynamic where someone is inserting some sort of undue influence or power dynamic over another and forcing them into some sort of a sex act.
Okay. Moving on to page 2. Now, let me ask you, it's been a month. This person has identified herself in the complaint, or her attorneys have. Would you prefer to call her the plaintiff or by her name, which is given in the complaint?
Not having nearly the experience in any sort of a format like this, I have a hunch that I will bounce back and forth between the two, either Miss
Okay.
Grant or alternatively the plaintiff. And you'll see probably as this legal action plays out, you'll see a lot of that where people use names synonymously with terms plaintiff or defendant. I have a hunch that it's
Why?
probably bad habit on the part of attorneys. I don't have a better explanation than that. Uh, we become maybe a little too familiar at times with our clients. Also, there's a penchant to humanize people in the courtroom. You want to use names. It could come down to styles make fights. It's stylistically what someone is more comfortable with. Again, I will probably bounce back and forth between the two, is my guess in speaking
Okay.
with you.
Perfect.
I personally do not have a preference.
Okay. So moving to page 2. This is from the complaint. Quote, McMahon befriended Miss Grant, giving her hopes of a new life with promises of a yet-to-be-determined role at WWE and showering her with attention and assurances, along with gifts like a VIP experience at WrestleMania. But what seemed like a dream in the spring of 2009 quickly became a nightmare, unquote. Matt, this story, this whole document seems very non-legalese in terms of a court document. How common is this graphic detail in a complaint?
Well, in the totality of the complaint, civil suits, there's a term called trial by ambush that's frequently used that courts frown upon. And the idea is that you plead your case in specificity to make sure that for the first time, once a jury's sworn in, that you're not making accusations that were not subject to the discovery process or subject to interrogatories because the other party didn't knew it or know about it. It's a combination of fundamental fairness and making sure that there's an even playing field in the interest of making sure that you're not subjecting yourself to an appeal or a mistrial or something along those lines. You need to plead your case in explicit specificity. It's a smart legal decision on the part of the individuals filing the suit. Now, as far as sort of mapping this out, you have what might be a preamble, an introductory area. It kind of provides a roadmap because this is heavy subject material for people to read and get to. And I thought that the introductory area really does do a great job of sort of explaining what you're going to be moving through. Some of it becomes duplicitous when they get into the specific facts and circumstances. I think in some cases they even use the same wording. But I've had a number of individuals who are not attorneys who have asked me questions about this, and they read this front to back, 67 pages of a legal document. That right there suggests that they've done a very, very good job of creating that roadmap and guiding people through and telling a very, very concise, even though it's elongated, a very concise narrative. And back to the comment I made before, styles make fights. A little bit of this is stylistic. We talk about in the law that you have to find your voice. You can't try to be something that you're not. If you aren't comfortable using these very broad legalese terms, or even if you are, but your writing style doesn't lend itself to that, you're doing yourself and your client a disservice by trying to be something that you're not. If you're just a natural storyteller and you're great at weaving a narrative, stick with that. I can't obviously put myself in the shoes of the plaintiff's attorneys here, of Miss Grant's attorneys, but I think that there's probably a combination of all of the above. And the last thing that I'll touch on here is there's a degree of this being there's a degree that anytime that you have a celebrity trial like this, it's going to be tried to a certain extent in the court of public opinion. You've got to make sure that the public is able to get through something and understands.
I've never read anything. There's no reason for me to read a complaint. I know 50 people who've read this thing.
And when you think about that, think about when the Wall Street Journal article initially dropped and it sort of pulled maybe the 3 or 4 super salacious parts of the complaint out and said these are the nature of the accusations. And you had people that were immediately sort of jumping to that there's no way this can be true model. Well, once you read the complaint itself, the narrative is done so well and it's not legalese. It's something that people can digest and chew on and really sort of get through and understand. It's again, it's an in my opinion, it's a very, very well written document, and it's done where I think anyone can understand it. And now she she is not someone that that I think there's going to be a caveat to everything, but based upon the strength of this document, I don't think she's someone that's going to get raked over the coals by talking heads or media or so on and so forth. And that's a testament to how well written this is and how easy it is for people to move through it.
Moving on to page 3, quote, after succumbing to the pressure for a physical relationship, Ms. Grant was slotted into an entry-level position as administrator coordinator. That was the job, a position McMahon created for her in WWE's legal department. You are a partner in a law office, Matt. Explain this job.
Good question. I don't. Their law firms come in so many different shapes and sizes. You have small boutique practices, you have solo practitioners, you have individuals that are in moderate sized firms. Sometimes you have these gargantuan practices. And then, of course, you have corporate law firms that are under the umbrella of an actual corporation itself. I guess the term corporate law firm is probably wrong. It's actually the in house counsel for that corporation. In candor, everybody has different names for positions. Some people refer to legal assistants as legal secretaries or paralegals. And in some cases, a paralegal actually has to have a certificate to meet that qualification. Everyone has a different name for their office manager or office administrator. I'm speculating a bit here, but this does sound at least a bit like it's some sort of an HR role within the legal department that's an in-house legal department under the WWE umbrella. But that is pretty rampant speculation on my part to try to figure out exactly what's meant by a made-up job that it appears at this point no one is contesting or has not yet contested the idea that it was a made-up job.
Pages 3 and 4, Matt. Quote, in March 2020, McMahon began sharing sexually explicit photographs and videos of Miss Grant, including pornographic content he recorded with other men, both inside and outside the company, including with members of the television production tech team, executive producers, and a world-famous athlete and former UFC heavyweight champion with whom WWE was actively trying to sign to a new contract and ultimately did sign that contract, unquote. Question. Are you able to discuss the law in terms of someone sharing a pornographic video? Let me put it simply. If someone gives me permission to record a pornographic video on my phone, let's say in an intimate moment, and I show it to 20 other people, do they have any rights to go after me in terms of permission, consent, etc.?
Yeah, so there's a couple of layers here. This has become an extremely hot button issue because of the prevalence of we now have mobile movie theaters and mobile cameras just on our person at all times, the way that cell phone technology is developed. And unfortunately, it's become very commonplace, at least for a time. And I haven't specifically seen the statistics, but I can't imagine that it's dropped off where people choose to engage in the act of what's commonly referred to as revenge porn, where they are
Right.
sharing something that it was filmed in the context of the relationship and they do not have permission to share it, and then they share it after the relationship goes sour. So there's no federal law, federal criminal law that prohibits that. So the federal government cannot prosecute someone. The United States Attorney's Office cannot prosecute someone for engaging in an act like that. That said, there may be a legal recourse civilly to sue someone, and I believe it's under the Violence Against Women's Act specifically, and is going to be codified under Chapter 15 of the United States Code, Section 6851.
Here we go
Yeah.
again. Here we go. You're mentioning codes
Yeah, I'm
again.
mentioning codes and I'm mentioning the written
Okay.
law. And
All right. Tell us what that is.
yeah, so again, this is where this is actually codified, where legislators and senators and eventually a president signed off and said that this is the law of the land, that this is covered and is now the supreme law of the land under the supremacy clause. And
Hold on.
yes.
Explain codify. You've mentioned
Yeah.
codify quite a few
So
times.
written into law, it now is
Okay.
officially law.
It's law.
Yes, it is law.
Go ahead.
It's what gives the federal government the authority, or individuals the authority, in order to get to federal court. If the law doesn't exist, you always have to establish jurisdiction in a lawsuit one way or another. I can't just say I want to sue you and I'm going to federal court with it. I have to have some sort of nexus or some sort of tie to federal law that allows me to get into federal court. So, absent this law in existence, no one has the ability to get into federal court and file suit against someone in federal court because their private images or videos were shared without consent. This law allows someone to sue someone in federal court subject to other requirements. They likely would need to have some sort of an interstate commerce nexus or some sort of other jurisdictional requirement, the crossing of state lines, for instance, or the use of a wire service of some kind in order to establish jurisdiction to get into federal court. But this at least gives a pathway to get there. Now, this doesn't include, for instance, there's 46 states, and this was just very cursory research, so it doesn't take long to learn these facts. 46 states and the District of Columbia have actually published or codified or created laws that criminally prohibit the act of revenge porn. So the sharing of an image that someone does not have consent to share, and that image being explicit or sexual by nature. The penalties for these acts range anywhere from misdemeanors all the way up to felony offenses.
But federal law has not caught up with it?
Well, and it probably becomes very complicated for the feds because normally in order for them to prosecute, there has to be a constitutional basis to get into federal court, something that they specifically have authority under. So the most common place being in what would be referred to as an interstate commerce nexus. So the federal government has the ability to control all commerce throughout all 50 states, the District of Columbia, as well as other territories like the U.S. Virgin Islands and Puerto Rico, for instance. If you are breaking the law and a part of that law breaking involves interstate commerce, now the federal government has the authority in order to prosecute. But absent that nexus to the Constitution, to the federal government and its specific powers, they don't have that. The example that's probably pretty easy, take Kansas, for instance. If you transport a gun into Kansas And at one point, we had I don't know if this has changed recently, but as of recently, we did not have any gun manufacturers in Kansas. So if a firearm was used in a crime in Kansas, you immediately have an interstate commerce nexus so that the federal government theoretically could prosecute that particular crime. Now, again, the federal government has to have an act that's actively prohibited to do so. So it likely would need to be something on federal land, or alternatively, they would need to have, say, for instance, you're robbing a bank with that gun, and banks are all federally insured anyway, so there's an automatic interstate commerce nexus in order for them to prosecute. But my guess is, even though you can sue civilly and potentially get up into federal court civilly, there probably is a concern about how enforceable would this be. And maybe it's best for the states to dictate this. And the reason being is because, again, this example that we're working with Vince McMahon and Miss Grant is going to be a fairly unique example because they're living that wrestling lifestyle where they're in one town one night and then another state away. There's so many conflict of laws along the way, so many automatic entries into federal court based upon how many states the WWE is doing business in and how many times she's moving across these state lines. Not to mention the gifts and the money and everything else that we're factoring into this equation. But normally, when you have someone showing a picture, if that picture was taken in, say, Oklahoma, they're probably showing it to people in Oklahoma. Sure, you have the example where someone is broadcasting it out in a larger, say, social media or across those platforms. But normally, when you're showing it, it's going to be far more personal. That means that any criminal prosecution is probably best served at the state level. And again, you're getting me a little bit into policy considerations as to how people are factoring in how to write law, and
Okay.
that's a little bit
Which
of a
we don't want to
guessing
do.
game with how legislators and senators function.
Okay. Moving on to pages 4 and 5. Quote, again, when I quote, it's all from this lawsuit.
And real quick, touching on, if I may, just real quick. So these penalties for breach of privacy can be very, very damaging. And again, I'll
Quote unquote
revenge porn, which again
Okay.
is going to fall under various definitions or various written laws. In Kansas, it's referred to as breach of privacy. That's where we've put this particular subsection. It's a low-level felony that typically people are going to be presumptive probation on, but if a sexual finding is made, you could be facing 15 years of sex offender registration upon conviction. So it's not that these don't have some teeth to them, these laws, even at the state level. So it's the act itself can give rise to real criminality that could be prosecuted.
Moving on to pages 4 and 5. Quote, as one example of McMahon's extreme depravity, on May 9th, 2020, he defecated on Miss Grant during a threesome and then commanded her to continue pleasuring his friend. Bolded in the complaint, Matt, is the phrase with feces in her hair and running down her back. Unbolded. McMahon went to the bathroom to shower off. Upon his return from the bathroom, McMahon and his friend actively resumed the threesome, which lasted over an hour and a half, while Miss Grant remained covered in McMahon's filth, unquote. The phrase, Matt, quote, with feces in her hair and running down her back is in bold in this complaint. I don't remember ever seeing bold in a filing. The complaint, so in terms of this whole thing, the complaint is scary enough. You bold a lot in complaint filings?
When do you want to get your point across? Again, that's a stylistic.
The complaint doesn't do it enough?
Well, if you think that might be your silver bullet that you want to draw everyone's attention to and not have them look away, because it would be easy for someone to just skim that, and if they're repulsed or they're disgusted, move on to the next stanza. You bold it, it's the idea, at least I would think. in theory, is that you're not letting them move away from it. That's the part that you read. That's the part that sticks in your craw. And again, I think that this is a stylistic thing. You see attorneys do this in different ways. Sometimes it's bold, sometimes it's italic, sometimes it's the overuse of exclamation points. Sometimes they're going to use a paren and then insert the phrase emphasis added and then close paren, which the emphasis was already in the statement itself. You're just drawing additional attention to it. This is probably one of the uh, amongst others, but this is one of the worst acts that you see outlined in the complaint. And it's terrible. And I imagine, and again, this is speculation, they're driving as hard a point home as they possibly can. And yes, the phrasing itself, the description provided, should drive a point home. But if you have that point and you don't want people to forget it, what is clicking one little filter, one little emblem up on your word processing unit in order to really make sure that it can't be forgotten? That's what my thought would be in that.
Moving on to page 5. Quote, in June 2021, McMahon and defendant Laurinaitis sexually assaulted Miss Grant inside Laurinaitis' office in WWE headquarters while colleagues were busy at their desks. Behind a locked door, the two men cornered her and pulled her in between them, forcibly touched her before ultimately putting her on top of a table in between them. She begged them to stop, but they forced themselves on her, each taking turns restraining her for the other, unquote. Matt, explain the legal aspect, if there is one, of workers having a right to feel safe in their workplace. Do I have a right to go to my workplace and feel safe?
Oh, you absolutely do. And there are two laws that have specifically been passed that cover different aspects of employee safety. The first is the Occupational Safety and Health Act, which is OSHA,
OSHA.
correct? And that's now overseen by the Occupational Safety and Health Administration, OSHA. That's going to be that you have the absolute right that employers are required to provide employees with safe working conditions and make sure that they're free of any known dangers to health and well-being. This was passed back in 1970, so it's going to be well post sort of the robber baron era, but I always kind of feel that these kind of safety measures are in order to prevent going back to those sort of robber baron eras where people would be worked to death and quite literally could lose limbs and what have you in a workplace environment.
Hey, this crane is really close to hitting us. Hey, I see mold everywhere and management isn't doing anything about it.
Or as simple.
That's OSHA to me.
Yeah. Correct.
And you're saying the sexual assault,
that's covered by a different law.
Portion of this?
That's covered by a different
law.
Okay. So starting with, you have the absolute right to be safe in your environment, in your work environment. And you're right with the examination there. You're on a crane and it hasn't been maintained properly by your employer. Your employer has a duty to maintain that crane properly, or mold everywhere, like you said. But then we go to sexual harassment in the workplace. And the Civil Rights Act, which was passed back in 1964, Title VII of that act specifically articulates that you have the right not to be harassed in the workplace, taken advantage of sexually. And it specifically outlines sexual harassment and the fact that it does give you action to go after an employer that engages in sexual harassment. So the act of sexual harassment itself, and now this is beyond the pale. This is so far beyond just sexual harassment, what's outlined here. We have issues of sexual battery, assault, rape, etc., etc., etc. We have clearly what I believe to be, again, as they've laid out in explicit detail, what looks to meet the federal definition of human trafficking or sexual human trafficking. So this is so far beyond sexual harassment but there absolutely is a law that says that you have the right to be safe from sexual harassment in the workplace.
Page 5, quote, in the days ahead, McMahon put Miss Grant under immense pressure to sign, saying that refusing the NDA, saying that refusing would not only jeopardize McMahon, his family, and the company, but that she'd surely become a public headline, suffer reputational ruin, including the pornographic content McMahon had captured, and face McMahon's legal resources. Conversely, McMahon reassured her that her signature would ensure his continued support and protection and safeguard her reputation, unquote. Matt, this sounds like a threat. Is the threat made by Vince McMahon allegedly illegal, and do courts look at this unfavorably?
Well, if you look clear down to the end of the complaint, where they're laying out the causes of action and the prayers for relief, what they're wanting to get out of the filing of this lawsuit, one of them is the invalidation of the NDA. And with their prayer for relief that they make, it's very much what I would characterize as a shotgun through a screen door approach. They're not looking to say, grant it just based on this one thing. Grant it based on all of these things, because they're all inappropriate. They all render this unenforceable. What we're talking about here, be it a threat, be it coercion, we're really talking about the term that's used in the prayer for relief is undue influence. And an individual that puts undue influence on someone to sign a contract, if that's proven, it may very well invalidate the contract. So, yes,
Okay.
the threat itself, I mean, is this in and of itself illegal? Is it a criminal action? Is it something that she can file a civil lawsuit in and of itself over, that she could get something out of Mr. McMahon and or the WWE? Well, not necessarily, but it certainly could invalidate just this alone. And that's not the only thing that they're alleging in order to invalidate the NDA. This could give cause to invalidate the NDA.
Let's get to that. Quote, ultimately, Ms. Grant succumbed to the pressure and signed the NDA in exchange for payments, which McMahon later stopped making, unquote. You have an NDA, right? You're supposed to pay X amount of dollars on April 1st. April 2nd, you haven't paid. When is an NDA voided?
Well, so an NDA is going to be a contract at the end of the day. So it's going to be governed by contract law, which means that anything that invalidates a contract is going to invalidate an NDA. That could be undue influence. It could be that it's overbroad. It could be that it's been disqualified by a new law that was passed or an existing law on the books. The thing that you have to be careful about with non-payment or non-specific performance on the contract is that it may not in and of itself just automatically invalidate the contract. Your cause of action for the non-payment on the contract may be to file a breach of contract claim and request specific performance on the existing contract. For instance, rather than say that this is null and void, the courts may say your actual prayer for relief, your appropriate course of conduct would be to file a breach of contract action and force Vince McMahon or the WWE, whoever was the party that was supposed to be making the payments in this. And obviously, to the best of my knowledge, the NDA is not out there as of yet. I'm sure that it may be made public at some point or filed under seal once the discovery process really gets going in this particular case. But it's entirely possible that rather than just throw the baby out with the bathwater, they may have said, well, instead, you sue him so that he then gets back on track with paying.
I'm moving to page 7 now, Matt. Ms. Grant seeks a declaratory judgment that her NDA is invalid under federal and state laws and asserts claims or others, including the Trafficking Victims Protection Act, which you mentioned earlier, passed in 2000 by Congress and signed by Presidents Bill Clinton, reauthorized by Presidents Bush, Obama, and Trump. It's an amendment to the Violence Against Women Act. Terms used under this act include involuntary servitude, debt bondage, a commercial sex act, meaning any sex act on an account of which anything of value is given or received by any person. In your expert opinion, Matt, is this the correct charge to be used in this situation? And what other charges could have been levied, and why did they use this one?
Well, this is the first time that I'm going to take a little bit of umbrage with your word choice here.
Okay.
So there are specific rules about lawyers holding themselves out as experts or specialists.
Okay.
In order to be qualified as an expert, I have to have received some kind of accreditation, normally by a professional organization, that typically involves sitting for some kind of a test or exam. And then that test or exam and or certification has to have been vetted by the American Bar Association. So I'm not going to hold myself out as an expert here because I don't believe that I meet any of that criteria. It would be improper and unethical for me to do so. What I can tell you is I believe that this is the appropriate statute to file under because A, it provides a clear path into federal court. B, so if you wanted to be in federal court from the start, you have to have some federal law that gives you the ability to be there. Number one. Number two, we talked about how sexual harassment or filing under the Civil Rights Act, there may be a claim based upon sexual harassment. But what really is the sexual harassment, again, seems to pale in comparison to what we actually have going on here based upon the factual allegations that are laid out. So sexual human trafficking appears to meet the proper definition and be the most, I suppose, heaviest law that is available to get into federal court. So I do believe that it seems to be appropriate under the circumstances.
Moving on to page 7. Quote, or excuse me, in addition to Vince McMahon, John Laurinaitis and WWE Incorporated, also listed as WWE LLC, is listed as a defendant. Matt, explain LLC and why it may or may not matter in this lawsuit.
Yeah, an LLC is a limited liability corporation. It's a means of establishing a business entity, and it's designed to protect business owners from the debts and liabilities of the business itself. It still creates a means of passing income through the LLC, so it has some of the advantages of different kinds of incorporation where you can still pass that income through as a profit distribution, but it's designed to shield the owners from those liabilities. So they've pled in the WWE. Well, the WWE encompasses a lot of folks, including shareholders of various different levels. And obviously, the other thing that has been brought up multiple times is TKO. Is TKO sort of the parent company of WWE and UFC now? And conversely, that whole umbrella corporation that they all fall under, all of this big entertainment conglomerate falls under, is there a means of protecting them from WWE if WWE is found liable? How deep down the rabbit hole to the deep pockets is this lawsuit going to go? So does the LLC provide a means of shielding the new owners, and it's just the entity itself, Vince McMahon and John Laurinaitis, that are actually going to be on the hook for any damages as opposed to everyone else that could be?
This complaint is filed in U.S. District Court in the state of Connecticut and says that Ms. Grant has cause for action under the Speak Out Act. The law prevents the enforcement of NDAs in instances of sexual assault and harassment. So does that mean that all NDAs in relation to sexual assault, Weinstein, this one, and harassment are null and void? Are those who signed one now able to speak without violating the NDA? And can the NDA specifically state that this contract supersedes the Speak Out Act. Like I get in an agreement with someone that, it's against Speak Out Act, but I say in this document, okay, we're saying this overrules the Speak Out Act, and you can never talk about it.
Yeah, no, that's a very fair question, and I'm sure that a lot of people would like that to be an answer, that they would be able to do that. Um, I believe that the Speak Out Act, if you prove that the NDA is tied to what the Speak Out Act is designed to invalidate, and that this all comes back to burden of proof. So Miss Grant files the lawsuit; she has to prove these allegations, and they've requested a jury trial. So the demand is that they go to trial in front of the trier of fact, and that trier of fact is going to be 12 individuals making a decision one way or another in federal district court. She has to prove the allegations to that jury. The jury then has to return a verdict in her favor. And then ultimately, it's going to be up to a judge to decide what the dollar amount is going to be associated with this. So when we start breaking these things down and really looking at them, she has to prove, and again, her factual basis seems to spell it out plain as day, that the NDA is directly tied to sexual harassment, sexual assault. If she's able to prove that under the Speak Out Act, it's invalidated. And no, a
Okay.
law cannot you cannot supersede a law. You can't contract around a law. If so, I mean, it's Pandora's box, right? You can contract around a law. The easiest example of this, well, murder's illegal, but our contract says it's fine.
Brilliant. Brilliant. Let's get to the factual allegations, Matt. Quote, prior to having any involvement with WWE, Miss Grant was dealing with profound grief following the loss of her parents, whom she cared for full time as their sole caretaker. The complaint already detailed this at the beginning, Matt, and now we have a factual allegations page. Why does it need to be said again? Is this a waste of the court's time if it's already been stated? And what's the difference between the introduction and factual allegations?
Well, I'd view it again, going back to when we started talking about this. This is all about pleading in specificity, and the parts of you don't want to accidentally lose out on something because you may have violated some sort of very minor rule of procedure. It's better to list everything out in explicit detail, and if you become repetitive because you gave a roadmap in the introductory portion and then you repeat yourself on the factual basis, that's okay. I don't think it's going to be deemed a waste of the court's time. I think that it's relevant to restate it because when you move on from the preamble into the specific facts, it appears they leave no stone unturned. And it's a very concise narrative. And in candor, again, it's a fast read. It did not take me very long in order to get through.
It is a very fast
For
read.
as heavy as the material is, this thing reads very quickly. And again, that's a testament to the individuals who drafted it. I think that going back again, this is a situation where I don't think it's a waste. Even if it's repetitive, it has a clear place in the narrative that they're telling during the factual basis section. So I believe, again, there's a little bit of speculation here, and I'm not the judge who's going to be making decisions on this, but it makes sense to me why it would be put in again.
Page 13, Matt. Quote, for each meeting with McMahon, Ms. Grant brought sample job descriptions she found online to review with him and demonstrate the types of roles she might fit in. McMahon listened to Ms. Grant, asked her questions, and pointed out qualities that he described as rare gifts, including her goodness, vivaciousness, childlike innocence, and ability to be vulnerable, all things that made her an easy target. Around that time, McMahon also told Miss Grant that he would never forget how helpless she looked when they first met, that he wanted to wrap his arms around her and assured her that everything's going to be okay and that Miss Grant's problems were in the past. McMahon also told Miss Grant that he viewed her as a true friend. Matt, is there a grooming law when two people are over the age of 18?
Well, the actual anti-human trafficking statute that we're dealing with is in fact the anti-grooming law. They don't use the term grooming.
Which says what to people who aren't lawyers?
Again, so I'm going to cite the statute again. I apologize. But going back to that definition section in that 22 USC 7102, and specifically the definition of human trafficking that you said clear back at the beginning of this conversation, what's one of the first things that's prohibited? Recruitment. Grooming is recruitment. It's maybe a synonym for it, maybe a different term for it, but that's what it is. That behavior for the purpose of subjecting someone to either involuntary servitude or peonage, debt bondage, slavery, or soliciting that person for a commercial act, that's really what grooming is going to fall under.
Okay. Page 21, Matt. This complaint details encounters during which McMahon caused Miss Grant to sustain physical injuries, including bleeding and pain from forceful use of sex toys. Despite Miss Grant's pleas to cease any further sexual activity, the number of sexual encounters increased, as did McMahon's physical aggression during them. Matt, nowhere in this document do you see a rape charge. Is the Trafficking Victims Protection Act much, much stronger statute?
Well, rape is going to be a criminal charge. So here's where we kind of go down a little bit of a rabbit hole.
Let's explain this. None of this is a criminal
Correct.
charge,
we
right?
keep using the term complaint,
Okay.
And complaint oftentimes is going to be something that's talked about in terms of a criminal action. But this is a civil lawsuit. And this is a civil lawsuit that's allowed to be filed in federal court because part of the anti-human trafficking law specifically allows individuals to seek civil remedy against their abusers.
Explain the difference between civil and criminal for those who don't know.
Criminal is going to be the government against you. It's state of X versus person Y. You have
Can you go to jail for a civil thing?
If you commit certain acts like contempt of court, in theory, yes, you can go to jail under a civil action.
Generally.
As a general rule of thumb, a civil action is designed in order to try to make someone whole in the only way that really we acknowledge in the good old US of A, which is money. And it's going to be a combination of actual physical damage that can be proven out, and that can be anything from doctor's bills to lost wages to therapy. It can be done in the form of attorney's fees in order to reimburse someone who had to pay a lawyer. And then there's such a thing as punitive damages as well, which punitive damages are designed to punish. This is saying that this act is so egregious that we're going to make you pay above and beyond what the loss was, because we can't actually put a dollar amount on that loss that is appropriate in order to show you that what you did was beyond the pale. So when you look at this act, this is all civil by nature. And there are two courses to get into civil court. There are statutory ways to get in, or written law ways. And then there's the common law. The common law are commonly referred to as torts or tortious actions. Those are going to be things like battery, assault, intentional infliction of emotional distress, negligent infliction of emotional distress. And you see some of these outlined in the prayers for relief. These are actual causes of action that they are bringing. So again, rape being a more criminal action, these acts of impermissible sexual violence, which it is not just the use of the toys and the situation in the office with Laurinaitis and McMahon and her, but it goes in some jurisdictions, the refusal to use protection when it's requested can fall under rape. So we have multiple instances as outlined in the factual allegations that might rise to the criminal level of rape. But as far as a civil action, these acts are all covered under the common law tort of battery. Battery being defined as any harmful or offensive touching. Now that sounds relatively innocuous when you think about it. Seems really broad. but it can cover anything from me pushing you and you falling backwards and hitting your head, all the way to me having a situation where I drive my car and create an accident that hurts someone, all the way to sexual violence. And I believe
Courts are not going to take he pushed me and I fell into a wall, are they?
depends on how hurt you are. If I'm the
Okay.
causation of something that bad happened as a result of, or maybe that wall was really expensive, I don't know.
Right. Okay.
But I
Okay.
think I think that rape is, these acts of sexual violence, call it sexual assault, sexual battery, rape, probably falls under some form of all three of those definitions. The only prayer for relief, the only civil action they can bring to encompass that, is the sexual trafficking, the intentional and negligent infliction of emotional distress, and battery.
Moving on, quote, McMahon was adamant about having Miss Grant send him explicit photographs, impressing upon her that it was part of her sexuality. Given the control that McMahon had over Miss Grant's employment, she felt compelled to comply and sent the explicit photographs to McMahon's mobile device. Ms. Grant was routinely assured that the photographs she was providing to McMahon were to remain private and were part of their secret world, unquote. Matt, the argument of my boss will fire me if I don't send these versus, well, she didn't have to send them if she didn't want to, is a really fine line, isn't it?
Well, if that's the defense they choose to run, they're kind of missing the boat, because
Go. Tell me.
if you're trying to wrap this into an idea that that these were all permissible actions, well, she's pled that it wasn't so much a these actions of trying to get her to send these photographs, send the sexually explicit contact or content, all seems to fall under recruiting. It all seems to fall under part of the grooming process that gets us to being done for the purpose of a commercial sex act. But if you're saying it's all permissible, sure, defense, it's all permissible up until the point that she didn't give you permission to share it with everybody else.
Matt, this entire complaint, I would say, is salacious. Does the court mind details like this in a complaint, or is the plaintiff required to emphasize everything that happened?
Well, it goes back to that whole concept of trial by ambush. I think the court would rather have, and again, every court's going to be different. Every judge is going to be different. Every judge is probably going to have different opinions on what should or shouldn't be pled in, how detailed something should be, whether or not there was a better way of saying something. But I think at the end of the day, a judge probably is going to be more appreciative of leaving no stone unturned and not trying to play hide the ball or gotcha, and trying a case with honor and with integrity, putting all your cards out on the table and saying, we want a trial on this and we're going to prove our case, as opposed to trying to introduce something for the first time in the context of a trial that's super salacious as a means of I don't know, prejudicing a jury. I It's difficult to put yourself in the mindset of a court, not specifically knowing that particular judge. The judges I appear in front of, some of them want extreme decorum. Some of them are more laissez-faire with the way things operate in their courtrooms. Again, everyone stylistically is a little bit differently. And certain defense counsel are a little fast and loose, and some are tight. There's no razor's edge that they're going to approach. Again, I think that most courts are probably going to want to take, especially with a suit of this magnitude, with public figures, with a multi-billion-dollar corporation, it's probably better, I would speculate, to get this out in the open now, as opposed to a trail of breadcrumbs that starts a media firestorm every single time that a court document is filed. And we may still deal with that as this thing progresses.
So let's talk about the threesome that was mentioned at the start of the show. Page 26. Quote, to induce Miss Grant's participation in the threesome, McMahon began referring to Miss Grant as his girlfriend and sent her a large bouquet of flowers. Nevertheless, on May 8th, 2020, Miss Grant expressed apprehension about participating in the threesome. In response, McMahon insisted that the plans were already made and suggested he would lose a friendship if he did not go through with it. Early in the encounter, McMahon immediately directed Miss Grant to lay down on her back in a supplicating position. While straddling over her, McMahon defecated on Miss Grant's head. McMahon left to shower off, but he instructed Miss Grant to remain in place with excrement in her hair and to continue performing for his friend. While Miss Grant requested protection, none was offered. McMahon and the physical therapist, who was mentioned in the document, actively continued with the threesome and directed Miss Grant's sexual performance for around 90 minutes while she was left covered in feces. Matt, at page 27, the complaint reveals the first text message that Vince McMahon allegedly sent, which we've all seen. I don't see how a jury isn't sympathetic to everything I just read.
Yep.
Okay. Page 28. On one occasion, he instructed Miss Grant, do not knock on the door, because if I see you, I will rape you in the hallway. Matt, this is the first time in the complaint that the word rape is used, but only because it's written in the text messages. Is the whole complaint coercion instead of rape?
No. Again, circling back to what we talked about a little before, I think it's covered under that common law tort of battery. And in many ways, it's going to be the foundational component of the cause of action for intentional infliction of emotional distress and or negligent infliction of emotional distress. I think that, again, battery being such a super broad term, it can encompass things like the sexual violence that's depicted in the complaint. So again, while the term is not used, I believe the term is not used because rape is a criminal act that someone does that is prosecuted by a government entity with the idea that they are trying to convict someone of that charge and then punish them accordingly, either with a combination of prison or probation or any number of different things that vary from state to state in terms of what that punishment could be. This is an outline of a civil cause of action that is designed in order to punish someone based upon monetary recompense, both to try to make someone as whole as possible, but I imagine that there's going to be some sort of a prayer for relief in terms of punitive damages as well.
Let's go to page 29, Matt. We have now there are about 7 or 8 text messages that McMahon allegedly sent that are put into the complaint. Do you see a lot of complaints that have text messages?
I don't, because in criminal law, the state has the burden of proof. So the state are the individuals that are going to be filing, and there are certain foundation requirements that may prohibit the state from introducing anything to a judge or jury absent foundation. The complaints that I see, again, being criminal, they're going to state what the allegation is, and they are going to very rarely state any sort of a factual basis beyond the nature of the allegation. It's going to state that on the X date of X, person Y did commit the crime of by and to wit did this act, and it occurred in a particular jurisdiction, thus giving them jurisdiction to prosecute. The including of exhibits, the including of attachments, it's not uncommon in civil law. Again, different rule system, different way of doing business. Surely at a trial, they will have to establish some sort of foundation unless there's a stipulation. But I don't believe they'd be precluded from including that. So no, it's not uncommon to include some kind of an exhibit in a civil complaint or civil filing of some kind.
I'm going to go to I'm going to read part of the text messages that were mentioned in the complaint. This is allegedly from Vince McMahon. Quote, I just passed my phone around to a bunch of guys on the tech crew. They were screaming, "Oh my God, she's fucking beautiful. Look at that ass. I'd like to get that." I paused to count out loud how many guys there were and then said, "Okay, there's 12 of you, and she'd love to F each and every one of you at one time." And the guys cheered. I'm going to stop right there. You talked about revenge porn, Matt. Any laws being broken here?
Again, it's going to depend on if you're in one of those 46 states and or the District of Columbia when this happened. But if you find yourself in one of those 46 states in the District of Columbia, you've committed some sort of an act that's going to fall under one of those revenge porn statutes by sharing that information if you were not specifically given permission to do so. The other thing is, and we haven't talked a lot about this, there's a criminal component to this anti-human trafficking statute.
Tell me.
So the federal government, the civil remedy is actually a subsection of this entire act. So this entire series of laws that have all been passed and signed into law that give the federal government the authority to oversee human trafficking investigations. They also have a subsection that specifically gives individuals the ability to file civil suits based upon themselves being trafficked. The thing that we really haven't talked about a lot here is if Miss Grant is proving this up, it doesn't preclude the federal government from seeking federal human trafficking charges against Vince McMahon and or any other party that they believe they can prove beyond a reasonable doubt did in fact engage in this behavior. So it's entirely possible that if this falls under, again, one of those definitions, be it recruitment, harboring, transportation, obtaining, patronizing, or soliciting a person for the purpose of a commercial sex act, or it falls under another one of those more severe human trafficking provisions, and a prosecutor was to believe that there was probable cause that someone, through the use of force, fraud, or coercion, did subject someone into effectively involuntary servitude or debt bondage, or alternatively used coercion, force, fraud in order to induce someone into a sex act. And of course, that requires they had not reached the age of 18, that particular subsection. But if we meet those certain definitions, we still could have criminal prosecution for these acts at the federal level.
Let's get to John Laurinaitis, Matt. Pages 32 and 33. In March 2021, WWE had still not hired a replacement after WWE corporate officer number 4 mentioned in the lawsuit. After this person was terminated in November 2020. As a result, McMahon stated that the plan was for her to change departments, and he verbally directed Ms. Grant to transfer to the Talent Relations Department, reporting to John Laurinaitis. On March 10, 2021, Ms. Grant sent McMahon a text message recapping their conversation and expressing shock and a range of concerns, including about Laurinaitis. Essentially, Ms. Grant expressed a desire to be treated humanely and taken seriously, which she acknowledged could be an uphill battle. Unfortunately, Ms. Grant's transfer to the Talent Relations Department came with the expectation from both McMahon and Laurinaitis that she engaged with Laurinaitis sexually, both physically and with explicit content. Matt, John Laurinaitis' attorney wrote this as part of a public statement, quote, "Like the plaintiff, Mr. Laurinaitis is a victim in this case, not a predator. The truth will come out," unquote. Matt, it appears like he is also claiming he is under the direction and power of Vince McMahon, just like Ms. Grant. Thoughts?
What else was he going to do? I mean, it's one of those deals where there's a finite number of defenses that you can actually run to something like this, because she wanted it and she was into it. That ain't going to play. It's just not. And the text messages that were sent to her, combined with all of the factual basis here, I mean, we've got receipts and we don't know how many receipts we have. We just have the ones that are included in the complaint itself. I don't think, and clearly there's been a conversation that, well, did she want it? Probably not if this is the tactic that he's taken. And my guess is that Mr. Laurinaitis has disclosed that to his defense counsel. We can't really play off the idea that this didn't happen. There's probably been a conversation that, yeah, it happened, because that's another defense you could run. So now it happened, but it wasn't either an actionable cause against me or it wasn't a crime, right? Well, how do we get there? Because it sure reads like it's an actionable cause against him unless he's a victim. With a finite number of defenses that you may have, this may be his only play, other than fall on his sword. I mean, he could do that, but I don't know how bad that turns out for him if he does.
Page 38, Matt. McMahon uses Miss Grant as a sexual pawn to entice world-famous wrestling talent and to keep WWE superstar under contract with WWE. This WWE superstar is famous worldwide as a top talent with WWE, with a large collective fan base that helps generate viewership and drives in-person attendance, all of which enrich WWE and McMahon. This WWE superstar has been described as a world-famous athlete and former UFC heavyweight champion with whom WWE was actively trying to sign to a new contract. Matt, without mentioning this person's name, and we all think we know who the complaint is referring to, if the complaint is wrong and this person or anyone else mentioned in the complaint had nothing to do with what they are accused of doing, do they have legal recourse in terms of this lawsuit damaging their reputation?
Yes, this would be a defamation of character action, which would be another civil action claiming that your character has been harmed as a result of false statements, either libel or slander. And it would be similar to the civil action that's taking place here. The difference in a defamation action is that you're hopeful that, number one, you're going to get some sort of a declaratory judgment that specifically says that, yes, you were defamed. So now you have a judge or a jury that said that, yeah, what was said about you was in fact false. And you've proved that in a court of civil law. Hopefully, if the person was actually defamed, this would be a degree of character regeneration, if you will, where now I've proved it in a court of law that this was false. And then it becomes a question of, is there any money at the end of that rainbow for the same kinds of things? Lost wages, damage to character, if you can actually put a number on that. In the case of famous folks, it could be loss of sponsors, could be loss of other opportunities. There may be more actual loss that someone can point to in the case of a defamation suit. It may be easier to point that out, especially if the individual is, again, someone who's famous. But there still may be the opportunity, even after that, to go after someone for punitive damages.
Let's go to page 44, Matt. Between on January 27, 2022 and January 28th, there were unresolved edits that led to panicked phone calls, including an attorney confidentiality clause and signatory line that Ms. Grant's counsel said he would never sign. The deadline to sign the NDA was pushed up from January 31st to January 28th. Explain the attorney confidentiality and signatory line. What's the holdup here?
I'm guessing they want to try to plead the lawyer for Ms. Grant into the actual NDA. That's how I read this. The lawyer that represented Ms. Grant would automatically be covered by attorney-client privilege, but that attorney-client privilege would only extend to Ms. Grant. If she were to waive that attorney-client privilege and he was not subject to an NDA, which she would be able to potentially do, there's nothing that would potentially stop him then from spilling the beans about everything. The idea, I'm guessing, and again, this is speculation, and I certainly understand why the lawyer said that he would never sign it. It feels ridiculous. I'm not a party to the action. I'm an officer of the court. I'm representing one of the parties. Why are you trying to rope me into this? So I understand why he would not want to sign that, and he's probably of the mindset, I'm covered by attorney-client privilege. I could see how the other side would say, we want everyone who ever had eyes on this thing and or talk to someone who is a part of this to be a signee of or signator of the NDA.
Pages 45 and 46, Matt. After the NDA was signed, McMahon, wearing only a white robe, met Miss Grant in his condo to review outstanding business items. As Miss Grant was proceeding to the door to leave, McMahon grabbed her arm before she exited and commanded her to do one last thing and get on your knees. On March 2nd, while Miss Grant was away on a trip to Florida, McMahon called Miss Grant to advise that it would probably be the last time she would hear from him, and if she needed anything, to contact WWE Corporate Officer Number 1 or Corporate Officer Number 2 named in the lawsuit. Towards the end of the conversation, McMahon and Miss Grant agreed to resume contact after WrestleMania. He also instructed Miss Grant to continue having sexual relations with other men, including a WWE superstar. In the meantime, on or around March 4th, this WWE superstar messaged Miss Grant that he was in New York. In line with McMahon's orders, Miss Grant texted WWE superstar explicit pictures. Matt, I've never thought about this until now. The signing of the NDA doesn't mean the behavior is going to stop. Don't NDAs usually have a no contact clause in them between the parties? I can't imagine that Weinstein's attorney would have said, okay, and you can't contact her again.
Well, that would be the intelligent thing, but there's an issue. There's a couple fold issues. Even if there's a no contact clause in the NDA, what's the client control? What prevents someone from actually doing it? It's a threat, but the behavior itself is actionable. We're not dealing with individuals here who are dumb. At least we've never thought of them as dumb previously. Vince McMahon.
This looks pretty
really
dumb.
But maybe it's just a function of someone getting away with something for so long that they think that they're Teflon or they're invincible. I don't know too many folks that have gone to trial against the federal government and won when the feds had built an extended case for an extended period of time. I don't have an answer for why you do this other than, again, it's pure stupidity. Because once you get the NDA, even though, again, there may be multiple ways that this thing was invalidated. Again, look at the prayers for relief here. But once you think you got the NDA, you have to have thought that you're home free, and you just have to quit the behavior. But apparently that wasn't the case. He must have thought that he was home free and he was just home free, period. But I don't have an explanation. It's pure stupidity.
So per the NDA, the first payment of $1 million is made on February 4th, 2022. A second payment is due 10 days later, I believe. And on February 28th, a payment for $10,000 is sent to cover the attorney's fees for Miss Grant's NDA. No other payment is ever made. As an attorney, Matt, how long would you wait before you would proceed with further action the day after the NDA payment is not made?
Well, I would have to defer to someone that practices in the contract arena and knows where you might be waiving certain actions or how long you wait and then you no longer have a cause of action. I don't have that information right off the top of my head, but I can't imagine that I would wait long if I was in a civil position before I sent a demand letter at very least, which would just simply be a letter that was sent from a lawyer on behalf of the client in this case on behalf of Miss Grant, saying, you're in violation of the terms of this contract. Let's get caught up, buddy. Obviously a bit more professionally worded, but you get the gist.
I have done my best to not speculate and go by the law and ask you questions as a criminal defense attorney. Now I'm going to speculate. Assuming he has the money to pay the NDA he's entered into, why would you stop paying? The contract you have created is not being honored. So do you think no one is going to talk at this point after you've only paid a third of it? You have an attorney who, why is this not, the money not going through the attorneys? And why are you stopping?
Well, the first thing is we started with the assumption that he's actually liquid to that extent.
It's $3 million.
The question becomes,
okay,
how much of that is tied up in stocks? How much of is tied up in other investments and other properties? What are his payments like? What are his debts versus actual liquid asset? So many high net asset individuals or high net worth individuals may not be as liquid as we think that they should be or are. Because again, it's tied up in property, it's tied up in LLCs. You see it where it becomes a bit of a game of chess or checkers with the IRS of how can I invest this fast enough into a different company so that it becomes a loss leader that I can then claim a loss on my taxes. That said, for the sake of argument, let's assume that he did have it. I mean, here's the thing. If you've gotten away with it before, and we've heard stories about it, some of this is not speculation. Not paying in full for Stu Hart with Calgary. And there are other instances, particularly during the territory era where the national expansion happened. And these are, Hornbaker's got books about this, and I think Ringmaster is another one that's published regarding Vince and the expansion. It's not anything that I'm relying on or speculation. These are published sources that people have gone to primary and secondary sources to vet out. And in some cases, there are people running podcasts now that were there when it happened, when some of these deals went crosswise. So I think it becomes a situation that when you get away with it for so long, why do you think this is going to be any different? I agree with where you're coming from here, by the way. If I was the lawyer in this situation and my client stops making a payment, and assuming that I'm made aware of that, because that's the other layer to this, if it's not going through lawyers, which probably would be the smarter thing, or maybe the lawyers didn't want the hush money intermingling in their trust accounts and what have you, which there may have been a part to that.
How do you not? You're the lawyer. Hey, you're due. Okay, per this agreement, which I helped, $3 million is due. $1 million is due. Send it to me or drop off a check, and I will have my office send it to them.
Yeah, or maybe it's plausible deniability, and all I did was draft the document.
You're the lawyer.
I don't disagree. I'm just saying.
Page 52, Matt, the NDA according to the complaint, the NDA violates the Speak Out Act and thus is unenforceable. This is void because the confidentiality term is overly broad on its face. Ms. Grant, it prevents Ms. Grant from saying anything to anyone about WWE or her employment there, which she would need to talk about or write if she was applying for a job, let alone exposing McMahon and other sexual assaults and abuse of Miss Grant. Matt, is Miss Grant really violating the NDA if she puts on a job application she was employed at WWE?
It probably depends on the language itself. I mean, if the language specifies that she never talk about her time period at that point, then yes, she might be in violation of the NDA. And does that make the NDA overbroad? I would. There's a real argument there that yes, it's overbroad because it doesn't cover the specific conduct that's really at heart here. But in an overbroad contract, typically what happens is a court is going to look at that and strike the overbroad part. They won't necessarily, especially if there's a savings clause within the contract, which would be a clause that says if any one particular section of the contract is invalid, strike that section. Again, don't throw the baby out with the bathwater. Don't throw the entire contract out. But here, you have overbroad, you have undue influence, you have the violation of the Speak Out Act. How do you strike one particular subsection as being overbroad when the entire thing is violative of the law? And we've already talked about the fact that you can't execute a contract that allows you to effectively violate the law. So when I go back to that whole concept of this is a shotgun through a screen door approach, they're naming every single problem that this NDA has. And each one of these individually might end up invalidating the NDA in its totality. But you take all of them together, and it almost seems like a fait accompli, where it's almost an impossibility or inevitability that this NDA is going to be found to be invalid.
Ms. Grant was moreover coerced into signing the NDA merely 8 days after she spoke to an attorney who McMahon initially approved of and then cautioned Ms. Grant against trusting before she was railroaded into rejecting all of her own attorney's comments. This occurred because of relentless pressure, including implicit and explicit threats by McMahon. Matt, do the courts ever look sympathetically at a party whose attorney was recommended by the opposition's party for the same case?
Well, if the attorney certainly failed in duties of competency or fiduciary responsibility or some sort of an ethical violation, or alternatively committed malpractice. But here's the thing, it doesn't sound like this guy did. As a matter of fact, in certain cases, like take a prenup, for instance, in Kansas, typically you're going to be required to pay the fees for the spouse to be if you've requested a prenup, because the idea being that, again, you're the one requesting it. It's only appropriate.
Oh, I didn't know that. That's a great point.
In this particular case, yeah, it is appropriate. You're asking for this NDA. Well, I don't have the money to pay some bigwig attorney to read over your person's draft, and I certainly don't have the ability to pay someone to drop everything they're doing to get this done over 8 days. And then this guy actually made changes that ultimately she got pressured into, because just because the attorneys are doing something, it doesn't preclude a layperson. McMahon's attorney or WWE's attorney is prohibited from contacting Miss Grant once she's represented by counsel. That person can't speak to another person who's represented. But McMahon is not prohibited from talking about the legal action with Miss Grant because he's not a lawyer. So there's nothing that says that Vince can't go in and again, read it. If you read the plain language here, he's the one putting the undue influence. He's the one putting the coercion. He's trying to make sure that she ultimately doesn't go along with the changes that her own attorney made. Now, we don't know what those changes are. Maybe they are hogwash, but assuming that they would have been to her benefit, McMahon talked her out of taking those changes to the NDA. So, yeah, if this guy was some Jake leg that was just on the WWE payroll, I think that people are going to have a problem with that. And maybe there's some sort of cause of action against the attorney for malpractice at that point. Or alternatively, there may be an argument to be made that the entire contract itself is fraudulent because it's insider dealing or what have you. But what we have here is it actually appears, based upon everything that's outlined in the factual basis, that this guy did his job, including objecting to him signing on as a party to the NDA, that lawyer speak out clause. And it's McMahon who had the problem with this guy. Why would McMahon have a problem with the guy if he was doing his job to the benefit of McMahon? It probably means he's doing his job the right way.
Matt, the NDA, the complaint says the NDA did not even include basic terms as she was promised by McMahon, including that he would pay for her lawyers, medical care, and taxes. Even if enforceable, McMahon has breached a core term of the NDA. He paid $1 million but failed to make any further payments, including the installment of $500,000. I said $1 million earlier, it was $500,000 to be paid within 10 days of February 1st. Matt, if you're supposed to get $500,000 by February 10th and $10,000 comes for attorney's fees on February 28th, but nothing else, as a lawyer, what do you do?
Yeah, that's when, if I'm made aware of it, that's when a demand letter would go out that says get back into compliance. Like we said before, it's going to call someone out for breaching the contract. And then the question becomes, are we going to try to invalidate the NDA, or are we going to try to sue for specific performance? Normally, the goal here is to, I mean, again, this is such a unique circumstance because the NDA on its face just feels gross and wrong, and there's so many issues about it, from undue influence to coercion. But just taking it at face value, taking that this theoretical attorney doesn't know about all the back channel dealings that McMahon has gone through, or it's overbroad for a reason. That's the other question here. Is it overbroad for a reason because they didn't want to talk about sexual assault in the NDA? And that's rampant speculation on my part. But we haven't seen the NDA yet. We don't know exactly what it outlines. Long and short, though, is that I'm sending something, or this hypothetical attorney is sending something that says get into compliance or get your client into compliance, sending it to the other lawyer. He's out of compliance, get him in compliance, or else. And or else is typically some sort of a lawsuit.
There are 9 charges against McMahon, Laurinaitis, and WWE. I won't mention them all here. What are the complaints is that the NDA is clearly one-sided and it's void against public policy. Do you have any comments on any of the charges that stick out to you?
As to the NDA, or just as all 9?
Just in general. Just in general, we're going to finish up here.
I think that it's appropriate, everything that was outlined, from intentional infliction of emotional distress to negligent infliction of emotional distress to, as we talked about before, there's no civil rape, but battery certainly encompasses the acts of sexual violence that are outlined within the complaint. And so I do believe that everything is appropriate. It's pled well. It lists all claims and causes for relief from the invalidation of the NDA, and then it lists multiple different areas in which the NDA should be invalidated. I don't think they missed anything here, certainly. And like I said before, I think that this is an incredibly well-written document, and they did just a marvelous job on it. Subject matter notwithstanding, but of course the attorneys can't control that.
This complaint was designed for everyone to read. And I asked you, why is this so salacious? You told me that Trump and Weinstein changed the game in terms of these things. Tell me about that.
Well, and it's even deeper down the rabbit hole than that. When you look at it originally, before kind of the Weinstein situation came out, or E. Jean Carroll, for instance, with the defamation suit that was filed after Trump's activities, after she came forward as a victim of his, you are seeing more propensity towards belief of victims. I think so. This idea of, and you brought up the concept that, I forget how you phrased it, but my boss, the fine line between I did this in order to keep my job,
they didn't have to do it if they didn't want to.
And that all comes back to the I wanted it, the slut shaming approach. They all wanted it. Weinstein and his activities really changed the game with Me Too. And even outside of Weinstein and Trump, look at even the wrestling bubble that we've dealt with in a small period of time with Joey Ryan and a number of other independent wrestlers who were taking advantage of trainees, who were taking advantage of young women who were on roster. We have seen a shift from there's no way this could have happened or this is ridiculous to oh, that's within the realm of possibility and we're willing to give it a read. And then when it's outlined like this and there's no holes, and that's the other part about this narrative, and that's the other part about even being a little bit repetitive. There's no holes in this complaint. It doesn't leave anything out. It's very difficult to pick this apart, at least on its face. And again, I think that there is a complete change in terms of belief of victims. And let's, at very least, there's a movement towards let's let this thing play out as opposed to cast judgment against the party that's filing.
You're a criminal defense attorney. Have you ever seen anything like this in terms of details and stuff like this? And yes is okay. I'm just asking.
Nothing like this. I mean,
this hits. Go ahead.
Look, I've seen some pretty gnarly stuff over the years. That's probably the best way that I can phrase it without getting into any details, which I will not do. But this is really something, from the grooming behavior to the acts of sexual violence to the out and out. I mean, I guess, again, in an office setting, to have two people while theoretically the receptionist is next door holding someone down while while she's telling them to stop, to the I mean, it's depravity combined with it's Marquis de Sade level stuff that we're dealing with. That's really the closest comparison that I think you can draw in literature, or and I'm sure that someone has worked just a tremendously awful case that has a fact pattern that might even outdo this. I'm not saying that this is the worst thing that anyone has ever seen. But when you read this, it's just it really is. It's that level of depravity meets violence meets control meets power dynamic meets who everyone up until this point thought was, for all intents and purposes, brilliant and maybe is just a nutso and a deviant. It's without passing judgment on any party, it's difficult not to once you read through all of this.
As a criminal defense attorney, this hits your desk. How do you respond?
Well, again, in a criminal case, if this hits my desk, this is
right. Not a criminal case.
This is a civil action. So in a criminal case, if this hits my desk, someone has been charged with a crime, and my first thought is, are they in jail or are they on bond? Are we having this conversation across the desk from each other? Am I having to visit them in professional visitation? The fact that this is not a criminal action where this is going to get initiated by means of an arrest warrant and someone's going to get taken into jail is an advantage right there to the person that ultimately is defense counsel. But this is a very serious client interview that you have to know everything. And that's really where any case, criminal or civil, is going to start, is in interviewing the client, getting a read on the situation. What am I actually dealing with here? Am I dealing with a person of sane body and mind at this stage? Am I dealing with someone who's going to be telling me the truth? Sure, I guess that there's probably a lawyer or two out there that doesn't want to know the truth. But I don't know how you craft any semblance of a defense strategy or even broach a settlement, for instance, or release of claims or work a case without knowing every assorted detail of exactly how deep down the rabbit hole goes and whether or not this complaint is not only 100% true or where there may be embellishment, if any does exist, which of course I'm not saying that's the case here. But, and then whether or not any embellishment is even material to the situation at hand, or if it's just part of the fact pattern that gets us to the part that's really damaging. And then there's probably a hard conversation had with the client. And if it is true, I would imagine that any civil attorney that's representing someone with significant means is probably having a conversation with the other lawyer of what is it going to take to make this go away. Civil cases settle all the time. Criminal cases settle in a different way. They settle through plea negotiations. I don't know if there's a scenario in which Miss Grant and her lawyers are going to walk away from this. I don't know if there's a dollar amount that they could actually present, they being the WWE and or a combination of the WWE, McMahon and Laurinaitis could present that removes them from this suit. I just don't know. And there may not be an amount. And it may be a situation that the client doesn't want to settle. Because Lord only knows what the thought process is, like you pointed out before. Someone that signs an NDA, begs for the NDA, coerces to get the NDA, and then immediately goes out and engages in the exact same behavior once the NDA is signed. Are they capable of knowing that they did anything wrong, assuming that the facts are true? And in that case, are we just riding this ship down? I would be incredibly hesitant to sign a contract with anyone from a defense perspective if I'm going to be the one that's caught holding the ball at the end and takes all the blame because they can't recognize that what they did was abhorrent. Lawyers always have the ability to decline representation. Sometimes that's the best decision that someone can make.
Miss Grant's lawyers say there are others that will be coming out. Do you believe that?
I have a hard time not believing her attorneys. Again, when you look at the narrative and the way that they crafted this, they put all their cards on the table. I have no reason to believe that she'd start lying now, and it seems like she's an upright officer of the court and has done everything above board here. And while it may be salacious, she's just calling them like she sees them. So I have a hard time disbelieving that. And I have a hard time disbelieving it given some of the stories that have been circulating, particularly since the early to mid 2000s. And I don't want to go into detail on any of those. I don't think that this is the purpose of what we're doing here, but where there's smoke, there tends to be fire.
If other things come out, will you return to join us to analyze
If
everything?
you will have me, I would be happy to.
Absolutely, we'll have you. Some final thoughts, Matt Leavitt.
What's more to say at this point? When you have 67 pages that are written that well, there's not a lot to touch on with regards to the facts. I hope that anyone that chooses to take the time to listen to this, that had questions about how civil law works or criminal law works, or had questions about, say, why this is pled the way that it is, that we've been able to give a little bit of education. This is not in any way meant to be legal advice, that said. I think that if you yourself are seeking answers because you feel like you may be the victim of something like this, it would be vitally important to speak to an attorney that practices in this particular area, and specifically someone in the jurisdiction in which this occurred. Lawyers have specific rules about the jurisdictions in which they are licensed and the legal advice that they can give based upon their licenses themselves. So again, I would find it vitally important that you reach out to an attorney in the jurisdiction in which this event occurred in order to discuss what your rights might ultimately be.
And we're going to put up the number to the National Sexual Assault Hotline right here, 1-800-656-4673. You can also find help and assistance at RAINN.org. I'm Efren. This has been Special Report, the complaint against Vince McMahon.